Happy Friday to all you all. This is Omar Srunda with the Tilted Lawyer podcast. It is Friday. It is podcast day. I have a lot to get to in the course of one afternoon. We're going to see if we could get it all done. Not all just on this stream. This stream is going to be devoted to Blake Lively. I have, well, evidence. And I'm going to talk about those things since so many of you guys have asked. I'm going to talk about what she was doing on live TV yesterday, talking about she's standing up for victims' rights and this and that, what it all means. I have some thoughts about that. Look, the reality of this is, I don't know, there's a lot of lawyers that cover this case. There's some lawyers that cover this case superficially. There's some that go in depth. There's some that are invested in like the academics of it all. Which category do I fall into? I don't know, probably like all of them. But at the heart of it, I am, many of you know that are my subscribers that I am a family law practitioner. I've been involved, just my background. I started off as a working in the DA's office as an intern while I was in law school. I got that perspective, and then immediately upon graduating, I became a criminal defense attorney. Did that for a couple of years. I've practiced in immigration because I worked for a law firm that wanted me to do immigration-based work. I learned that body of law. I very rapidly rose up at that firm to take over their civil department, which I had no business doing at the time, but I was doing it anyway. And so I've gotten all of these backgrounds in law that have given me this perspective that I have on the case. And what I practice right now, about 60 to 70% of what I do is family law based, and specifically, I deal with a lot of actual victims of SH, of SA, of domestic violence, and similar things. I deal with actual victims, and that's not limited to women. Some men have been victimized. I've represented people that were making accusations or allegations regarding children. Just really heavy topics. And this week in particular has been particularly trying. I try to stream as much as I can, but in the course of this week, I have had a number of cases that have just dealt with a lot of heavy topics. And, one of the big drawbacks to being an attorney is that you don't sometimes get to pick and choose your topics. Sometimes you're beholden to the needs of your clients. And, not even if you wanted to turn the case down, your internal focus doesn't allow you to look away. And so when you have those kinds of cases, it weighs on your soul. It saps you of motivation. It makes you exceedingly depressed. And you have to find outlets. You got to find a way to deal with it all. And then I run across a case like Blake Lively that we've been covering since December, and I get a whiff of her 17-point list. I try to stay objective. I really do. I try to stay objective with the things that she claims, with her perspective, and her autonomy as a woman. I hear her say things that she said yesterday, and I remember that there was a time when Blake Lively was like a 6-year-old little girl, and, hopes and dreams or whatever, and good for her. She made it in Hollywood. She's made a career for herself, but she's not inherently a bad person. And so much of our coverage of this case it's not been one-sided, not on my channel. I've made legal observations. It looks to me like Baldoni has the stronger case. I make no bones about that. Matter of fact, by percentages, I would say like 70-30. But there's been a lot of backlash towards Lively. And, from some of the things that I've said, and I don't take any of it back. I won't take any of it back. I try to understand who she is and where she's coming from. The things that she's saying, is it calculated? Is it the words of a narcissist manipulator that is trying to spin the hands of PR? Maybe, maybe. Have I been swayed by it? No, I haven't. Let's not get that twisted. I still have my thoughts and opinions. And for right now, my mindset right now is one of great empathy towards actual victims that I'm actually representing in my cases, who deserve advocacy and deserve an outlet, a forum, a voice to express their fears, their very genuine fears, and to be able to tell their story. Neither one of them have an outlet that Lively has, this stage, this platform, and yet they've been hurt the most, from what I could gather from the actual evidence, physical evidence, digital evidence, telephone evidence, surreptitious recordings, and the like. And so, with all that, I have some things to talk about with Blake Lively, and we're going to get started on that as soon as I run this intro coming up next.
Whatever you might be going through and wherever you might be, this is Omar Serrato with the Tilted Lawyer Podcast. I'm here to take your mind off of things. Yes, I'm an attorney. No, I'm not giving you legal advice. We're going to sit and talk like people, as these are the candid thoughts of one practicing attorney, and it's after hours. So have a seat. Feel free to have a drink and join me. Let's get started.
All right, folks. So I believe it was last night or the night before, or I don't remember. I don't know what day it is anymore. It's Friday, I know that. But she went on late night television and she said the following. I'm going to share my thoughts with you. This is what she said.
You mentioned you had an intense year. I'm maybe not as totally informed about it as other people. But
I'm thrilled you're not doing Weekend Update right now because you would be quite informed.
Okay.
So it's good, yeah.
But were I to ask you about it, I imagine you're in a situation where you can't say much.
Yeah, I mean, what I can say without going too into it is that this year has been full of the highest highs and the lowest lows of my life. And I see so many women around afraid to speak, especially right now, afraid to share their experiences. And fear is by design. It's what keeps us silent. But I also acknowledge that many people don't have the opportunity to speak. So I do feel fortunate that I've been able to. And it's the women who have had the ability to use their voice that's kept me strong and you know, helped me in my belief and my fight for the world to be safer for women and girls. It's a pretty simple thing, but you know, nothing. Thank you. It's true.
I'm certainly going to respect that you're in a position where you can't talk about it more. And I obviously think a lot of people hoped we would talk about it more, but I think we gave them that crushed ice thing.
Yeah, no. I think that's what they came for.
I think they're going to be like, oh, thank God. We were like, there were two things we wanted to talk about, and they did that. They did the first song in Frozen. We were obviously.
And I sang the song from Frozen.
Did.
So like, what?
All right. So that was pretty much the gist. So she goes out and she positions herself as an advocate for women's rights, the same way that Justin Baldoni has for, decades now. She doesn't say anything, obviously, about the details of the case. We know what they are. We know what her allegations are. We know what the worst of it is, and I'm not going to rehash them here. I've often said that the allegations are not worthy. Honestly, they're 12b6able. They are dismissible. They are motion for summary judgment worthy. Perhaps, maybe. There's some tribal issue in there, right? But, I mean, to the extent that that's all there was, knowing everything else that I know about the lawsuit, I have opinions about her version of events. And I have stronger opinions about her attempting, on the basis of that 17-point list, on the basis of the allegations inherent in her First Amendment complaint and her original complaints, to position herself as if she's been the victim somehow and that she has to stand up for what's right, because not doing so will act as a barrier to other women who require and need an outlet to be able to share their very real stories of the things that they've gone through and all this and that, whatever. What I know from the women that I represent, that are actually being represented, that are actually experiencing being victimized because of horrific things that have been done to them, they don't look at Lively as a hero. They don't look to her as like this bastion of bravery. They look at her with disdain and disgust because they don't take her seriously. And they think that her plight is cheapening their very real plight. And they think it's a grave disservice to women that are undergoing what they're going through. A young lady being intoxicated beyond consciousness to wake up and discover that she was essayed by her boyfriend and his friend. And then they just F off to wherever. A young lady who had the audacity to underseason food, prompting a huge argument with her husband that led to her physical destruction, basically. I mean, a smashed in face, pretty much, unrecognizable in pictures, month-long stay in the hospital, among other things, and a daughter that witnessed it all. And yeah, there was a pushback to them sharing and telling their stories. But what was that pushback have to do with? It had nothing to do with whatever Lively thinks it is. It's because the forces that are controlling those women are right outside of their inner circles, like their family, extended family. What is my mom going to think? What is his mom going to think? What is my children going to think? All of these external pressures, whatever. And that's a different discussion that we don't have to have right now. All I'm saying is, my only point is, when I hear Lively position herself that way, and just to say it like so haphazardly and robotically, I don't know the lady. I don't know what her normal mode of communication is. I've never watched any of her movies. I haven't watched It Ends With Us. And I'm certainly not watching her new Amazon movie, whatever it is. It just came off disingenuous. It came off callous. It came off scripted. It came off rehearsed. It came off as, hey, look, is there anything that I can do to steer PR in our way? And then their attorney's like, yeah, just say this. You're saying everything while at the same time saying nothing at all. And so, that's what's going on with Lively. That happened. So I know people get frustrated because they think this is the only case that I cover. It's not. I'm going to be talking about Jennifer McCabe's testimony right after this, like at 2:00, because I think that they may have, look, I thought this about the first trial, but I think that Jennifer McCabe may have tanked the prosecution's case. Obviously, it's not over, but there's a lot to talk about there, and I'm going to go over that around 2:00. And then, of course, I got Vlad. Rob is going to be joining us. Rob is in the chat for the first time. He's going to make his Vlad debut, and we're going to see how he does. And so look forward to that. Pardon me. Let's get to the lawyer stuff, right? That's what I should stick to. So let me stick-to-itiveness. I know that doesn't make sense. Where is my PDF window? Here it is. Okay. All right, so these are the motions. Look, the motions are like the most boring part of this. There's not much reason to cover this. It's been covered by Laura Knighty. I haven't really seen any other attorneys cover it, but you guys have been asking about it and have some definite opinions about what they're trying to do. What I can tell you, having given this a once-over, is that this is pretty common fair discovery battles. There's not really a whole lot to see here. The Lively parties are demanding more detailed answers and trying to fight like hell, to skew things their way. And the Wayfarer partners saying, what do you mean? Bullshit to all of that. We've given you everything you asked for. And by the way, you're being disingenuous and bullshit to this and this and that. And you're asking for things that are not relevant. We did not waive our privileges or we did not waive our objections. 33.3 is a thing. It was in our boilerplate objections to every single thing. So that's kind of what's going on. Honestly, I could just tell you that and you could leave and have a pretty good understanding of what's going on. But I'm going to go in a little bit more depth than that because that's what I do. So this was their motion to compel. On behalf of Leslie Sloan and Vision PR, the Sloan parties, we write pursuant to individual rule 4.c, and they want stuff. They want extra answers with respect to interrogatories number 3, 4, 5, and 7. They state, after 4 months of disassembling and issuing vague and inconsistent statements through their attorneys, the Wayfarer parties have yet to identify the basis for their claims against the Sloan parties, including but not limited to the statements they claim defamed them or put them in a false light, when or how those statements occurred, and to whom those statements were made, as set forth from the Sloan parties. Motion to dismiss. The Wayfarer parties were required to, and by the way, you could imagine what the retort's going to be. Yeah, we did. We did in our amended complaint, and we amended it, whatever, we said the plan, whatever, you have all the things. They continue. The Wayfarer parties were required, but did not provide this information in their complaints. Wayfarer parties' opposition brief provided no further specifics, stating only that they know and allege that Sloan made statements to reporters referring to Baldoni as a SP and accusing him of SA, and ceded false information about Baldoni to the Daily Mail in an effort to do stuff. The Wayfarer parties somehow made these factual assertions despite previously including in their now dismissed California action against the New York Times an image capture of that Daily Mail reporter conceding to Brian Friedman and Melissa Nathan that I had many conversations with Sloan and Blake, and never once did she say anything about SA. Well, I guess case closed, right? I guess we could all go home. Dismiss this bitch, and let's be done with this and move on to the next thing. If, as it appears, the Wayfarer parties have no Rule 11 basis for their claims, they should be forced to make that admission in discovery now. That's a pretty common tactic that I use. When I know that there is no evidence on the other side to support a cause of action, I will file a request for admission, making them say that. And then when they say that, I want you to admit that you have no evidence written or tangible that support your cause of action. And it forces them to either confirm or deny, to admit or deny that request for an admission. And when they admit it, then I just put it into a motion for summary judgment and use it as fodder, ammunition to get the case dismissed. That's what they're essentially trying to do, but it's not going well. They knew that it wasn't going to get dismissed. It's just it's what people do. Is it going to go anywhere? No. I think that ultimately what's going to happen with all these discovery responses is that the judge is going to make them whittle it down a little bit. But I don't think that Wayfarer is getting compelled to do stuff. And I don't think that their answers as they currently stand are going to be all there is. I think what's going to happen is the judge is going to make rulings on these objections and ultimately make a decision about what is going to be the final or scope of discovery regarding these specific interrogatories. So if it appears, oh yeah, they got to say that. So interrogatory number 3 requests that the Wayfarer parties identify each person that you allege the Sloan parties communicated with regarding the Wayfarer parties. The relevance of this interrogatory is obvious, given that the Wayfarer parties are asserting claims for defamation and false light based on unidentified conversations Miss Sloan allegedly had with an unidentified person and at unidentified times using unidentified words, which, to be fair, is a pretty good argument. for them disclosing, so who are these unidentified people? And what are these non-described conversations that you speak of? What they're getting at. There was a meet and confer. The Wayfarer parties clarified that their sole objection to interrogatory number 3 is that it purportedly exceeds the scope of local civil rule 33.3, which basically states that, look, you have to provide stuff to the extent that it's relevant. And what Wayfarer's argument essentially is that we lodged boilerplate objections to every single interrogatory to the extent that it exceeded the scope of relevancy in your request. And we did not waive it, and we didn't have to spell it out for you. It was already done. And so that's kind of the back and forth that's going on right now. As a threshold matter, the Wayfarer parties did not lodge a timely Rule 33.3 objection to interrogatory number 3 in their written responses. They don't go on to explain why that is. Then they go on to say, even if they did, even if the objection was not waived, interrogatory number 3 falls squarely within the scope of 33.3, seeking, among other things, names of witnesses with knowledge of information relevant to the subject matter of the action and information of a similar nature. In other words, they know that this isn't really going to fly. Local Rule 33.3a. This necessarily includes the names of witnesses, information relevant to specific claims. The Sloan parties require a response so they can target future discovery requests appropriately, which is a fair point. But you don't get to make the other side do all the work for you. You tell me what you're looking for. You can't just say, I want every conversation of everybody you've ever talked to for the last 20 years and whatever. That's unduly burdensome. It's not specific enough. You need to whittle this down and request what you're looking for, I think is the point. Their frustration is they're not getting as much as they want, or maybe they are. And they were going to do this anyway, which it doesn't really look like that's the case. I mean, it looks like they really believe that they're entitled to a deeper response. Not even that they believe that. I think that what their plan is, they're going to take interrogatories 3, 4, 5, and 7 and use them as the basis to try to inevitably file a motion for summary judgment based on the responses to 3, 4, 5, and 7. That's what they're going for, or at least that's, I think, what they're hoping for. We'll see. Where did I leave off? Absent more information, the Sloan parties are unable to assess which, if any, of the potential witnesses among the over 150 individuals and entities listed on the Wayfarer party's initial disclosures has information relevant to the claims against the Sloan parties. The Wayfarer party's objections to interrogatories number 4, 5, and 7 are equally meritless. Those interrogatories simply request that the Wayfarer parties identify each defamatory statement you allege the Sloan parties made concerning any of the Wayfarer parties, identify each of the malicious stories portraying Baldoni as a sexual predator, as alleged in paragraph 8 of your amended complaint, and identify each of the stories critical of Baldoni, including that Baldoni was SP, the head of the film's release, as mentioned in paragraph 282 of Stuff. Once again, during the parties' meet and confer, the Wayfarer parties objected to these interrogatories on 33.3 grounds. And then they're saying, but wait a minute, 4, 5, and 7 are seeking information of a similar nature. Basically what's contemplated in Rule 33.3. All they're asking for is basic information that is at the heart of the Wayfarer party's complaints. Obviously, Wayfarer's objection to that is, it is at the heart of our complaint, but not all of it is. In other words, a lot of it's not relevant, and you're not getting the irrelevant stuff. That's what we're talking about. They go on to give more case law and stuff. At a minimum, interrogatories number 4, 5, and 7 fall within 3.3. It's the same kind of thing. It would be inefficient and unduly burdensome for the Sloan parties to review every single statement that Miss Sloan has ever made, and then guess which one of these statements, if any, the Wayfarer parties claim is defamatory. Similarly, the Sloan parties need to know which, and honestly, that's kind of a fair point. But Wayfair has a pretty good retort. I'm going to get to their opposition, which just dropped today. I found that out from my good friend Lauren Knighty. The Sloan parties need to know stuff. All right. We're going to leave off. It would be impossible to complete discovery into allegedly defamatory articles, including document and deposition subpoenas to the journalists and entities that wrote and published them without a set list of what is claimed to be defamatory. Simply put, the Sloan parties need a basic roadmap of the claims against them to prepare their defense and target discovery. The retort to that is, yeah, you get a roadmap, but you don't get the whole effing schematic. We're not going to do all the work for you. You tell us what you're looking for. It has to be relevant. Tell us how it's relevant. And then there is I forgot one. The Wayfair party should answer request for production number 32. So the Sloan party also respectfully requests that the court compel the Wayfair parties to produce documents in response to request for production number 32. The Wayfair parties have repeatedly represented, both in their filings and in the press, that they have obtained additional information about the Sloan party's activities that they will add to their amended pleadings. Inexplicably, the Wayfair parties refuse to produce that information, even though it is clearly discoverable. And that's the breadth of what they're asking for. And now I will get into their opposition. By the way, how are we doing in here? Let's see. Oh, Rob is going off in the chat. Emily Cheek says that Judge Lyman is taking his time and looking at all the evidence from all sides, and more often than not, he has shown that JB team is bringing the more solid responses and argument. Honestly, don't know, Emily, if that's altogether true. I mean, I don't know whether or not he favors JB's team or not. I think he's pretty even-handed thus far. I mean, we don't have a lot to work off of. Just from what I can see in his rulings, he's been pretty even-handed. But I think we'll know a hell of a lot more once we learn what he rules on the merits regarding the 12B6s and some other things. We'll see. We'll just have to see. The one you don't know is waving at the chat. Picture of a bear. I like that. Okay. Let me get back to this. So, as counsel for Wayfair Studios, LLC, Justin Baldoni, Heath Sarowitz, it ends with us, all these things, are writing in opposition. So, the false premise of the Sloan party's motion is that they purportedly lack notice of the Wayfair party's claims against them. This is bullshit. That's how I would have wrote it. Maybe not just like that. They say, however, the Wayfair party's amended complaint alleges that the Sloan parties made statements to third parties, including the New York Times, to the effect that Baldoni is an SP who sexually assaulted Lively. I think if I'm the judge reading that, it's like, okay, so what were the statements then? Very broadly, we know that it involved accusations that Baldoni was a sexual predator who may have essayed Lively. But do you have specific statements? I think that's the argument. And if this was an oral argument, that would be a question. What specifically did they say? What statements specifically? That's what they're discovering. That's what they want to know. It's a fair question. And they would have some kind of an argument about that. And that Baldoni retaliated against Lively and others for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. The amended complaint alleges that the Sloan parties made further false statements in response to media inquiries concerning Lively's wrongful accumulation of power over the production, how she did so, and the resulting turmoil. Specifically, the Sloan party stated to the Daily Mail that reports of a power struggle on set were 1,000% untrue. Your info is totally off. You have it all wrong. Your reporters are so wrong. Instead, the Sloan parties seeded false information to cast Baldoni rather than Lively in a false light. The whole cast doesn't seem like Justin. Nothing to do with Blake. They, the Wayfarer parties, are panicking as the whole cast hates him. So they're just giving examples from the complaint about specific statements. The amended complaint also alleges that the Sloan Party made one or more statements to third parties, including to the New York Times, to the effect that the Wayfarer parties engaged in, permitted, and or failed to prevent sexually inappropriate conduct toward Lively and others and retaliated. In other words, they know enough of what we're looking for. They're not in the dark here. I think they got a pretty good idea of the modus operandi of what we're alleging. If they want specifics beyond that, I think they've gotten enough. And very clearly, we don't have all of the specific individual statements that were ever made where they were in the process of trying to brandish Justin Baldoni as a sexual predator so they can fuck off with all of that. Pardon my language. It is Friday. It's been a long week. I apologize. I gotta stop cursing so much. I really am sorry, guys. The pleading alleges that the Sloan parties and the New York Times, a false and damning story about an insidious PR sabotage operation deployed as revenge for sexual harassment complaints with the knowledge and intent that the newspaper would publish the false story, and that the Sloan parties propounded a false smear campaign narrative designed to destroy the Wayfarer parties. In other words, they are on notice of what we're going to allege. It's already been alleged. What we've alleged is sufficient. There hasn't been any kind of amendment or ordered amendment to hash that out so they can go pound sand. Now they address interrogatory number 3. It's overly broad. Just simply put, it's overly broad. They want us to identify each person that you allege the Sloan parties communicated with regarding the Wayfarer parties, as set forth in the Wayfarer parties' formal responses and objections. This interrogatory is not limited, and that's kind of the key problem, to limited to matter that is relevant to any party's claim or defense. You don't just get to have every person the Sloan parties communicated with regarding the Wayfarer parties. The way that interrogatory reads, literally, in its most literal sense, and the Supreme Court has been writing about the issue of legal interpretation for hundreds of years now. You take the literal meaning of that sentence, and they literally would be required to produce, absent an objection, every person that the Sloan parties communicated with regarding the Wayfarer parties, even if it wouldn't be relevant to a cause of action. It wasn't limited to that. There was not that limiter in the interrogatory, which is why they objected. The Sloan parties contend that the relevance of this interrogatory is obvious. Well, yeah, we see why it would be obvious, but you can't be so careless with your interrogatories, counsel. If you're going to ask for something like that, then just say what you mean. Limit it somehow. Limit it to communications that would have affected the causes of action relevant to the party's allegations against your clients. And then you'll be good. You can't just leave it open-handed like that, because obviously it's overbroad. I think that's what they're hoping Lyman. I honestly don't know if Lyman's going to say that. I'd imagine that's what he would say. I think that the Sloan parties have a point that, yes, it's relevant, but the Wayfarer parties also have a point in that the request is overly broad. This is my read of it. Wayfarer party. Okay. So, however, the interrogatory is not limited to identifying the names of witnesses with knowledge of information relevant to the subject matter of the action as required by the local rules. That is a rule. You can't skirt the law. I think that the judge is just going to make them limit the interrogatory to that. I think that's a pretty good way to limit it. Names of witnesses with knowledge of information relevant to the subject matter of the action. That's pretty artfully written. The Sloan parties conceded that interrogatory number 3 is overly broad, and they narrowed it to only seek the identification of people with whom they communicated to the extent those communications are relevant to the claims and defenses in this action. However, the Wayfarer parties responded to a different interrogatory seeking broader information. Interrogatory number 1 requests the identification of any person believed or known by you to have any information or knowledge concerning any events, fact, matter, act, allegation, or issue included in or raised by the complaint or amended complaint you filed in number 25 of the action. In response, the Wayfarer parties incorporated by reference their initial disclosures, which the Sloan parties admit disclosed over 150 individuals and entities. In other words, we gave them over 150 names in an interrogatory that already kind of asked this question in more broad sense, and we provided and gave them what they asked for. They asked us to identify any person believed or known by you to have any information or knowledge concerning any event, fact, matter, act, allegation, or issue included in or raised by the complaint or by amended complaint. That is pretty broad, but it's also limited by stuff raised in the complaint. So it's acceptable. And they answered it, and they give them over 150 names and entities. Contrary to Sloan parties' contention, the Wayfarer parties did not waive their local civil rule 33.3 objection. If you've ever been involved in discovery of any kind, you know that there are like these boilerplate objections that happen. Rather than writing them in every single interrogatory, just say, look, I'm objecting to every interrogatory to the extent that it's not relevant, would be an example of one. And that's kind of what they're arguing that they did. Case cited, proposition, case law. The court held that the plaintiff waived its rule-based objection because it never mentioned local rule 33.3 specifically and failed to explain why each of these interrogatories was objectionable under that rule. Here, the Wayfarer party's general objections, which are expressly incorporated into each specific response, objects to each interrogatory to the extent that it exceeds the scope of interrogatories set forth in the local civil rule 33.3. So they're basically saying they've done it by default and preserved that specific objection for every single interrogatory, even if it's not spelled out. They might get in a little bit of trouble with that because of this. Never mention local rule. Well, not that. What was I looking for? Oh, because of their failure to explain why each of the interrogatories was objectionable under that rule, which they still kind of haven't done. I mean, they're kind of doing it now. I don't know if that's going to be enough. Lyman appears to be a bit of a stickler, so we'll see. Additionally, the Wayfarer party's specific response to interrogatory number 3 explains that it is objectionable because it broadly seeks the identification of anyone with whom the Sloan parties communicated regarding the Wayfarer parties. The defendant therein violated the court's order by failing to respond to interrogatories by a specific date, which certainly is not the case here. As to 4, 5, and 7, they're looking for the identification of each alleged defamatory statement, each malicious story, each of the stories critical of Baldoni. These are impermissible contention interrogatories that exceed the scope of local rule 33.3. And they cite this law. In their plea for leave to exceed local rule 33.3, the Sloan parties disingenuously contend that they need a basic roadmap of these claims against them to prepare their defense. However, as detailed above, the amended complaint specifies the media outlets with whom Miss Sloan conversed, approximately when she spoke to them, and the words she used during these conversations, to the extent that the Wayfarer parties have specific knowledge of facts relating to her own defamatory statements. That's a big one. How in the F could we disclose every single statement if we still don't know what all the statements were? We're still discovering them ourselves, which is why, specifically why it's impermissible contention interrogatories exceeding the scope of Civil Rule 33.3. We're not required to disclose the things of which we don't know. And they have a sufficient roadmap to have a pretty good idea of where we're going with this, so they're on notice. And sufficiently, therefore, if Miss Sloan engaged in other defamatory conduct, she will not need to guess which of these are defamatory because she is the one who made the statements. As for her need for the news articles the Wayfarer parties allege are defamatory or otherwise actionable, she will obtain them in document discovery. As for request number 32, it's improper, and they say that it's looking for documents upon which the Wayfarer parties intend to rely in drafting a further amended complaint. A second amended complaint that does not exist, may never exist, and of course has not been filed. In response, the Wayfarer parties objected on the grounds that the request seeks information protected from disclosure by the attorney-client privilege. That's a really good point. Work product doctrine and any other applicable privilege. The Wayfair parties further objected to the request as premature because a second amended complaint does not exist. The case cited by the Sloan party stands for the unremarkable proposition that a party must produce documents referenced in its pleadings. If a second amended complaint is filed, the Wayfair parties will produce all non-privileged documents relevant to the claims, located upon a diligent search to the extent that such documents have not theretofore, I love a good theretofore, been produced, including any documents referenced in such currently non-existent pleading. In other words, they're asking for stuff that we haven't even put in pleadings yet. I'm not giving them that stuff because we may never have to amend this complaint. And they're already conducting discovery on the FAC. There may or may not be a SAC, Second Amendment complaint, an SAC. So we'll see. We respectfully request the court deny the Sloan party's motion to compel. Unfortunately, Sloan party's true purpose in filing the motion is not to compel discovery, but rather to re-argue their sub judice motion to dismiss, which they anticipate will be dismissed based on the court's discovery, denial of their motion to stay discovery pending their dismissal motion. He had to throw in that little last little jab there, didn't he? I loved it. Anyway, that is at the heart of what's going on with these motions to compel. What do I think is going to happen? I do think that 32 is premature. Hey, thanks, Rob, with the $5 says, thanks, Omar, for highlighting in the document what you're talking about, as well as the legal perspective in your opinion. It is, in my opinion. I do not speak for all attorneys. Many attorneys have different opinions. Much appreciated by us all. And I appreciate all of you as well. Thank you so much. What do I think is going to happen? I don't think that they're going to be required to respond to 32 because they're right. They're asking for information that is not yet in a pleading. And to the extent that it's not in any pleading, it is protected under privilege, I believe, under attorney-client privilege, attorney work product doctrine. And so I don't believe that they're entitled to those things. It's not ripe. I just don't think they're going to do it. I think that they're going to force the Sloan parties to whittle down their responses a little bit. We don't get to see specifically how the responses were written because they're under seal, but I imagine that there's going to be some ruling. I don't believe the Wayfair parties are going to be compelled to give further responses. I think that they're going to be forced to further meet and confer and figure this out on their own. And if the judge does anything, he's going to order the Sloan parties to write better interrogatories. Don't make them so broad. Ask for what you're asking for, not what you hope to get. Or, I guess, well, never mind. Anyway, that is the motions to compel discovery. Thank you, folks, for joining me. I'm going to be ending this stream in about an hour. I'm going to be doing a Karen Reed stream, so I hope to see you guys all there for that. Until then, I will see you guys in about an hour. And don't forget, after we're going to be doing Family Law After Dark, debuting our guest star, hey Rob, who is limited on space. We'll see you all there, man. I love you guys. Have a good week, and I'll see you. Bye-bye.